Hi, my name's Robert Sykes. I'm a lawyer at Bennett & Philp Lawyers in the Family and Relationship Law team, and I'll be talking to you today about recovery orders. A recovery order is an order that is made by the court that returns a child to either their parent or a caregiver, somebody who has parental responsibility for the child. So you can apply for a recovery order if you're a person who the child lives with, spends time with, or communicates with under a parenting order, if you're somebody who has parental responsibility for a child under a parenting order, or if you're the grandparent of a child or some other person who is concerned with the welfare and development of the child. So if you're the parent of a child and the child is removed from your care but there are no parenting orders in place, you can still apply to the court for a recovery order on the basis that you're a person who is concerned with the care, welfare and development of the child, notwithstanding that there are no orders currently in place. So if there are already parenting orders in place, you would apply for a recovery order by filing an application in a case within the existing matter in which those parenting orders have been made. If there's no orders currently in place, you would apply for a recovery order by filing an initiating application with the court, which will outline the orders that you're seeking be made by the court on an interim and a final basis, including orders for the recovery of the child. When deciding whether to allow a recovery order application, the court will ultimately consider what is in the best interest of the child as the overall paramount consideration. In determining what are the best interests of the child, the court will consider a number of factors such as risk to the child, any attachment that the child might have to either parent, any effect that disruption may have upon the child, and any other relevant factor that the court considers necessary. So there's no mandatory amount of time that you need to wait prior to commencing proceedings for a recovery order. As far as possible, however, you should try and resolve the matter privately without bringing the application as a first step. In some circumstances, it may be appropriate to bring an application urgently. However, each matter is unique and it's important that you obtain independent legal advice with respect to your particular matter prior to commencing any proceedings. When your matter is first before the court for a recovery order application, there are a number of ways that the court can deal with it. The court may decide that they do not have the capacity to hear the matter immediately and may adjourn it for a hearing at a later date. If the matter is urgent or if the court has the capacity to hear it, they may deal with the matter on the first return date and may make an order either in court or an order may be made later in chambers and released to the parties.